Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 114. Before I get into the usual process of running through the three cases, I wanted to start with a couple of pieces of news. First, I'm delighted to say that we have a guest podcast for you. We've not done one of them for a while, but an opportunity came up to do a discussion with Naomi Ellenbogen QC, who is lead counsel for the Home Office in the recent Supreme Court decision involving Mr. Essop. She very kindly came along to record a podcast with me to discuss the case and its implications for discrimination law. It's really interesting, trust me on this, and she's a really good guest too. The episode will come out probably later on this week. Do please take a listen to it, it's really informative. Secondly, I have a news update on one of the cases which we talked about in the last episode. I'd recorded it before the remedies decision was available, and I'm talking about the Dunkley and Costal case where, if you remember, the employer tried to sidestep collective bargaining and was found to have breached section 145B of TULCRA. You may also remember that originally the decision was a decision on liability only, but I commented about the possibility of significant damages award. Well, the upshot of the company's attempt, as decided by the tribunal, to sidestep collective bargaining, it's now set them back more than £426,000. As I say, that feels like an expensive lesson, and it is a dangerous piece of legislation to overlook. Anyway, back to the more usual matters. We have the usual three cases. The first is a case on dismissal for some other substantial reason. It's amazing how often this comes up in practice, where you have a dismissal that doesn't fit within the normal misconduct, redundancy, underperformance areas. This case looks at the standards of fairness required for an SOSR, some other substantial reason dismissal. And as I say, I think it's quite an important case. Secondly, we have a case illustrating the tribunal's obligation to look at the possibility of drawing inferences from primary facts in a discrimination case. I'll explain in a moment why I think it's an important area. Thirdly, and finally, we have a case on the ACAS certification process, the early conciliation process. This is an important point for external advisors to be aware of, particularly claimant advisors, but also in-house, given how the impact of time limits is always important. As usual, please don't forget you can access the podcast via iTunes. It's on the Mayor Brown website, YouTube, and the Twitter feed. Nicholas Robertson at Nicholas ROBER11. So on with the show, and we start with I think the most difficult name to pronounce on this entire podcast. One day I'll learn. Mrs. E. Sekisongi, I hope I've got that right, and Barts Health NHS Trust. As we all know, if an employee is dismissed and is able to bring a claim for ordinary unfair dismissal, it's for the employer to show the reason for the dismissal. And there are, in essence, four main statutory gateways through to fair dismissal: capability, conduct, redundancy, or some other substantial reason, such as to justify the dismissal of the employee. SOSR, some other substantial reason. This last reason is in essence a catch-all, but as I mentioned a moment ago, it is something that we see quite often in practice. It can arise in circumstances, for example, where the employer has lost confidence in an individual, but the individual has not been guilty of gross misconduct or gross negligence. It could apply if a customer announces to an employer they don't want to have a particular sales representative being their point of contact with the company. Some reorganisations of a company may not mount to redundancy as statutorily defined, but they could justify a departure, and you'd plead that as an SOSR departure. This case is very useful because it talks about what the test for fairness is in what may be a no-fault dismissal, i.e. the employee hasn't done anything wrong to justify dismissal, but the employer has a reason for dismissal. And the facts in this case are quite a good illustration of how this could arise. There are also complications, and it's quite a complicated set of facts. So this is only a summary of some fairly intricate comings and goings, if I can put it that way, set out in the EAT decision. So apologies if I'm summarising unduly. Claimant arrived in the UK and was given indefinite leave to remain in October 2000. Her name in her application form was Farida Mukabarisa. She was granted British citizenship in 2006. She then changed her forename to Elizabeth and subsequently adopted the surname of her husband to become Elizabeth Sekisongi. However, in 2007, the Home Office wrote to her questioning whether she was in fact the person she claimed to be, or whether in fact she was someone else entirely with a different nationality. In the meantime, by 2007, she'd qualified as a nurse here in the UK and had started working for Barts by March 2011. She submitted to Barts her right to work documentation and her British passport, but told them nothing about the Home Office correspondence that had come in 2007 and which was still outstanding. Believe it or not, there was then a 6-year gap between the original correspondence from the Home Office and them writing again. But the essence was that the Home Office continued to assert she was not who she claimed to be, and therefore her naturalisation was null and void and she'd never been a British citizen. Obviously, that all then affected her right to work. The claimant has challenged and continues to challenge this by judicial review, and apparently that's still ongoing. However, she didn't tell Barts about any of this, although according to the tribunal, she was obliged by her contract to do so. To cut a very long story short, although the claimant continued to assert and provide evidence that she was who she said she was, the Home Office did not accept this. The Disclosure and Barring Service in 2014 wrote to Barts to explain what was going on in their view, and as a result Barts suspended her pending investigation. The uncertainties continued, and eventually there was a disciplinary hearing convened by Barts to address the allegation that the claimant was unable to verify her identity and unable to prove she was able to work legally in the UK. The employer felt, during the hearing, that it could not await the outcome of the judicial review application, given that there remained a question about the claimant's true identity, which caused concern about her right to work and her right to practice as a nurse. Proper checks could not be carried out, and according to Barts, this meant there was uncertainty as to whether she was someone who was suitable to work with patients, and or whether there was a risk to patients if she was permitted to work with them. The appeal hearing relied heavily on the evidence from the Home Office and recorded that there remained reasonable concern about the claimant's identity and about her lack of openness and transparency in failing to tell Barts what was going on. The Employment Tribunal decision, when she claimed for unfair dismissal, was that the reason for dismissal was primarily about the uncertainty of identity. That was a some other substantial reason dismissal. The concern that Barts had about her failure to disclose to them about the Home Office correspondence was a lesser part of the reason to dismiss. The Employment Tribunal also decided that the dismissal and appeal panels at Barts had placed heavy reliance on the information provided to them via the Home Office. It was reasonable for them to take this information into account and to rely on it. There'd been extensive contact between Barts and the Home Office to try and clarify the situation. They'd not just sat back and accepted whatever they were told. And it was also important that the Home Office continues to maintain, I think to this day, that the claimant is not who she asserts she is. The tribunal also accepted it was not realistic to wait until the judicial review proceedings were concluded before deciding what to do with the claimant. So, although there were a number of grounds of appeal from the Employment Tribunal decision to the AT, the one I wanted to focus on was the first ground. What is the threshold for fairness in a some other substantial reason case? The claimant pointed out that SOSR dismissals include dismissals where the employee is not at fault in any way. On that basis, it was submitted, there was a higher standard imposed on the employer to show that a dismissal was fair for SOSR reasons than for, say, performance or misconduct where there was performance or misconduct. At first blush, this sounds quite attractive, but it didn't succeed. The EAT said the tribunal was entitled to find that there were genuine concerns about the claimant's identity. The fact that she was a nurse was also very important. There were reasonable grounds to be concerned about the identity, and given her role and so on, this enabled the tribunal to conclude that there was some other substantial reason for dismissal. The EAT did not accept there was a different standard of proof for an employer seeking to rely on an SOSR, and therefore this element of the appeal failed. I think if the case had gone the other way, it would have made life rather more difficult for employers, but confirmation that there is no special or different test for an SOSR dismissal is helpful and I think sensible. The EAT accepted this case was factually close to the margins, but it was relevant, they said, that the individual was a nurse rather than, say, working in the retail sector, where there might have been less of a risk to vulnerable patients. Nonetheless, the fact is that there's no higher standard of fairness required when relying on an SOSR dismissal than, say, for performance or misconduct to satisfy the test of fairness. So that's the case of Mrs. S.E. Sesisongi and Barts Health NHS Trust. Now, next case I wanted to talk about was the case that I mentioned in the introduction, looking at discrimination. This is Talbot and Costain Oil, Gas and Process Limited and others. This is about the basis on which tribunals can find that discrimination has occurred, unlawful discrimination, obviously. Now, although this rose at the stage of the Employment Tribunal hearing itself, I wanted to include this because I think it's a really good illustration of the sort of points that employers and their advisors should be looking for when dealing with these situations before they get into litigation. It illustrates the difficulties that tribunals have when looking at discrimination cases, but there are some useful lessons. They also make two other comments, and I think these are quite important. First, the case is continuing because the matter has been sent back to be reheard completely by a fresh tribunal. So at the moment we have no determined allegations, and when I talk about findings of fact, they're really matters that are identified by the EAT in their report. They're not actual determinations of fact. And secondly, as we all know, a case which is summarised after it's gone through an Employment Tribunal decision and an EAT report can often look very different to the way it appeared to the employers going into the case. Often they would understand matters differently with good reason. Bearing all that in mind, when I talk about the facts, bear in mind it's just a summary of matters identified in the EAT. So, against that background, Mrs. Talbot, the claimant, who was described by the tribunal as a very experienced engineer, having worked more than 30 years in the industry, was engaged to work for Costain on the basis that the relevant site she was going to, she was to shake things up on site. She was the only female candidate out of 12 whose CVs were sent to the company. She was the only woman in a male-dominated world. It appears that after she started work, a hostile atmosphere developed between the claimant and her male colleagues. This included them criticising her and her personality, apparently telling her she was arrogant and aggressive. She was told she should be gentler, kinder and generally nicer to the team she worked with. But after about 12 weeks, she was told that her contract was being terminated because of, quote, business HR changes, unquote, and that she had to leave site immediately. The company's defence asserted that in view of the work that was available on site, it was necessary to release one of the team of engineers, and she'd been selected because of concerns about her attitude and interaction with others. This explanation was rejected by the tribunal because the company had recruited another engineer just before the claimant's contract was terminated. Unsurprisingly, perhaps, the claimant brought a tribunal claim with multiple allegations of unlawful discrimination against corporate and individual defendants. But these claims failed, either because, according to the Employment Tribunal, she couldn't prove the facts, which she said involved less favourable treatment or harassment, or, where she had done so, her treatment was not because of or related to her sex. Her contract was terminated by the respondent, according to the tribunal, because it found that the individual who had made the decision considered she was not doing the work in the way he wanted her to do it, and therefore she wasn't getting enough done, and also he took into account the complaints about her from the others. The Employment Tribunal found that none of this was because of or related to her sex. The claimant appealed and said, amongst other things, the tribunal had taken an unduly fragmented approach to the evidence and that it applied the burden of proof wrongly. And perhaps, just standing back, and I emphasise very much my terms, a finding that by the tribunal that in effect amounted to she was really unpopular and disliked, and they got rid of her, is the sort of thing where you do think, we need to have a double take on this. We need to think twice about whether there is covert discrimination. Anyway, the EA took the opportunity to summarise the rules on determining claims of discrimination because, as we all know, it's very unusual to find direct evidence of unlawful discrimination. And the key principles are that the tribunal's decision depends on what inferences are proper to draw from the relevant surrounding circumstances. This often includes looking at conduct by the alleged discriminator, but they said you should do this both before and after the treatment in question. Tribunal has to make findings about any primary facts which are an issue, so they can take that determination into account too. Tribunal needs to assess the parties and their witnesses when they give evidence. This includes, in relation to the alleged discriminator, an assessment of his or her credibility, reliability, and testing their evidence by reference to facts and documents, potential motives, and overall probability that what they're saying is right. Importantly, the tribunal then has to stand back and have regard to the totality of the relevant circumstances. In this context, it is necessary to think about the inherent probabilities of what the witness is saying and how well it fits with facts which are neither disputed or which are indisputable. The EAT allowed her appeal. They said the tribunal had not reached views on the credibility of the witnesses and had not taken into account the inherent probabilities of which version to believe, where the witnesses, the claimant on one side, respondents' witnesses on the other, were telling different versions. The EAT also commented that documentary evidence could include things the documents do not say, because the absence of something could be important in a contemporaneous document as well as its presence. Equally, the company was found by the Employment Tribunal to have been in breach of its disclosure obligations in disclosing relevant data, and the EAT said that could be a factor too in deciding on credibility. To give just one simple illustration of all of this, the claimant had alleged that there were various team meetings, but that her comments at the meetings were dismissed by her manager as completely irrelevant, and it was said this gave rise to a potential inference of discrimination. The Employment Tribunal simply said they had no reason to prefer her version, and therefore she had not satisfied the burden of proof. The EAT said this wasn't good enough. The tribunal should have made an overall assessment of witnesses, taken into account the fact the company had failed to produce relevant documents dealing with the minutes of that meeting, had failed to take into account that the tribunal had found that her manager considered the claimant's role to be a waste of time. All of these are factors which could have been taken into account by the tribunal in coming to a view as to whether or not the claimant's version of events as to what happened at this meeting were to be preferred, or the respondents'. So I wanted to put this into the podcast because I think it's a really good illustration of the sort of things you should bear in mind if you are looking at the strength of an employer's case, particularly if you're on the company's side. You do need to step back and look at the case as a whole. Are there inconsistencies? Are there things which they're a bit improbable? Should there be documents covering particular points? If those documents have been lost, really? Is that unfortunate, or is that something that's going to cause a problem? If documents fail to deal with something, such as a comment made at a meeting, is that a surprising omission? Does it cast doubt on whether the comment was actually said? Overall, it's important to be dispassionate and objective about this. And here, according to the AT, they seem to be saying that there are significant gaps which might, and I emphasise which might, count against the employer in deciding which version of events to believe, and on the basis of that, whether or not discrimination has occurred. But as I say, the case continues. So that's the case of Talbot and Costain, Allgas and Process Limited, and others. Final case. The Commissioners for HM Revenue and Customs and Mr. M. Sarah Garau, Garau. This is a relatively short point, so I'll try and deal with it relatively briefly. It's connected with the mandatory ACAS early conciliation provisions. As the AT records in its decision, these provisions may do much good, but they also give parties something else to litigate about. The claimant is disabled, has been on long-term sickness absence. He was given notice of termination of his employment on 1st of October 2015. So, notice was due to expire 30th December 2015. He got in touch with ACAS 12th October 2015, i.e. 2.5 months before his notice expired. The early conciliation certificate was issued on the 4th of November 2015, which was some 6 weeks before his employment came to an end. So the whole ACAS period was done and dusted before his notice period expired. He then contacted ACAS again about the same matter 2 months after his employment had ended, and ACAS issued a second certificate on the 25th of April 2016. However, his 3-month time limit for bringing an unfair dismissal claim expired 3 months after the date of dismissal, i.e. 29th of March, unless the ACAS extension, mandatory extension provisions applied. Unfortunately for him, he didn't present a claim until the 25th of May 2016, and unsurprisingly, the respondents took the point that the claim was, they said, out of time. Now, ACAS mandatory provisions, as we all know, you can't issue a tribunal claim without having got an ACAS early conciliation number, a certificate. The ACAS mandatory early conciliation process can last for up to 1 month. There's a possibility for a 2-week extension, so maximum 6 weeks. And given that the parties can spend up to a month or 6 weeks on settlement discussions with ACAS, there are specific provisions dealing with the extension of statutory time periods. In general terms, you have 3 months from the date of dismissal to bring a claim for unfair dismissal. And broadly speaking, the ACAS process works to extend that. There's a sting in the tail, of course. broadly speaking, and I'm summarising the legislation, the tribunal says the tribunal rules say day A is the date on which the claimant contacts ACAS. Day B is the date on which the claimant is held to have received the ACAS certificate permitting the claimant to go ahead. In working out the statutory time limit, the period beginning with day A and ending with day B is not to be taken into account. So the question was, what happens here where the period from day A to day B, the ACAS period, falls entirely within the notice period, i.e. before the individual has actually been dismissed? Secondly, can an individual go back to ACAS for a second time and say then there's a second extension caused by that particular second approach to ACAS? The EAT is very clear. There was scope only for one application to ACAS, and that was the first one, whenever that was. Once that's happened and the certificate has been issued, there is no scope for another certificate to be issued. And so the second application to ACAS could not extend time. What about the first one? Bear in mind, as we go into this, that the time limit says it is 3 months from the effective date of termination. So what happens if day A to day B, the ACAS period, occurs before the effective date of termination? Well, the EAT said there's no requirement for day A to fall after time has started running. On that basis, although there was a gap between day A and day B, they had no impact on the statutory limitation period here, and therefore they did not operate to extend the date for submitting the tribunal claim. The claim was therefore presented out of time. It is still alive just because the matter went back to the Employment Tribunal to consider whether or not there was a basis for extending time on the normal grounds, i.e. it was either reasonably practicable or it would be just and equitable to extend time. But the claim is out of time otherwise. No, my reason for including the case in the podcast is simple. It's obviously odd to have a claimant trying to use ACAS twice over for the same complaint, but it's quite usual to find people contacting ACAS as soon as a notice of dismissal has been given, even if they are still working out their notice period. If the individual is on garden leave or otherwise being held for the notice period and approaches ACAS, then issues like this could be a dangerous trap for employees. Equally, employers and their advisors want to be aware of this case. It may mean that a claim is time barred, which otherwise would have gone ahead. So, that's the case of Commissioners for HM Revenue and Customs, Mr. M. Sarah Garau. So, thank you very much indeed for listening. I hope you enjoyed the podcast. Don't forget, we have the guest podcast that will come out later on this week. Don't forget as well, if you're in the UK and listening to this, register to vote in the general election. It's really important general election. Apart from that, stay safe and look forward to catching up with everyone ahead at the next podcast. Cheers.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.